Hello, everyone, and welcome into Senior Living Live. My name is Melissa, and we've got another fantastic webinar on tap for you today, featuring our guest speaker, Cindy Nelson. She is an attorney and the founder of Nelson Elder Care Law with offices in the Atlanta metro area. She specializes in representing seniors' rights and interests. Now, she's got a fantastic presentation for all of you today about estate planning, the good, the bad, and the ugly. We, of course, as always, want you to be a part of the conversation, so feel free to type any questions you may have for Cindy, either now or throughout the webinar. You can scroll down to the bottom of your screen and you will see a little button that says Q&A. Cindy will answer your questions at the end of our presentation, which we expect to last about an hour. So with that, the floor now belongs to Cindy. Cindy, take it away.
Well, thank you so much, Melissa. I appreciate it. And thank you for everybody that joined today. So I'm just going to go ahead and upload my presentation here so everybody can see it, and then we'll get started. So today we're going to talk about the dirty secrets, why your estate plan may fail. And you might want to think about, why should you listen to me? I'm Cindy Nelson, an elder law attorney. You can see that we've won several different awards. I've helped thousands of families to put their estate plan together and to make sure that it works correctly. Now, this is a disclaimer. I'm a lawyer. We got to have a disclaimer. So this is not legal advice. This is just for educational purposes. Our agenda today is we're going to talk about what is an estate plan. What does that actually mean? Because I think that there's so many different terms that get bundled together that aren't really clear. And then why do you need an estate plan? Does everybody need one, or do you only need one if you're a millionaire? And then we're going to talk about the dirty secrets, why your estate plan may fail. So we see a lot of estate plans that people have done over the years. And so I'm going to tell you some of the pitfalls that we see frequently in estate plans that prohibit them from working the way that they were designed. And then we're going to talk about what happens if your plan fails. What does that mean? So first, let's talk about what is an estate plan. So an estate plan is including legal tools for you to pick somebody that you have confidence in to be in charge of things if you're not able to make decisions yourself. And so some of that is while you're alive, and some of it is after you pass away. So while you're alive, if you become incapacitated, we need somebody that's going to be able to make decisions for you. And so the basic estate plan includes a medical power of attorney, along with a living will and a HIPAA authorization. Now, the medical power of attorney is where you choose somebody that could make medical decisions for you if you ever could not make them for yourself. And the living will is the document that says if there's no quality of life, that maybe if you're being kept alive by some type of medical procedure or medical equipment that you don't want to be. And then HIPAA allows your friends, family, whomever you choose to get information from your doctor. The other thing that's in a basic estate plan is a financial power of attorney. And that is where you choose somebody that's going to manage your finances, use your assets to pay for care if you can't do that yourself. So the powers of attorney are good while you're alive, but the minute that we die, those are no longer any good. They're terminated, and it switches over to the last will and testament. Now, you have to have mental capacity in order to sign these legal documents. And so how do you know if you have mental capacity or not? Well, you need to be able to understand what it is you're doing and what is the outcome of that? What are the consequences of the decisions that you're making? Now, some people think if I'm diagnosed with dementia, that automatically says that I don't have mental capacity, but that is not true. Mental capacity comes and goes. It's not a black and white thing unless a court has decided that you're incapacitated. Otherwise, I might have dementia. I might know what I'm doing right this minute enough to sign legal documents, but in 5 minutes, I might not know who you are or where I am. So it's very fluid with the mental capacity. So what happens if you don't have an estate plan? And I think this picture really captures it, because if you don't have an estate plan, it can become very stressful for you. But mostly what happens is the brunt of this is carried by the people that love you. If you were to lose capacity and you didn't have the powers of attorney, then that means you don't have the legal authority, or someone doesn't have the legal authority to make decisions for you. So let me be more clear on that. I usually see that people get trumped up by not having the legal capacity to make financial decisions for another person. And so if I'm a single woman and I have my bank account and I have my investment account, maybe my 401k, and I have a house, and all of those things are in my name. Well, if I become ill, then nobody can get into any of those assets to pay for my care. Now, a lot of people think, well, okay, well, who's your beneficiary? But the beneficiary doesn't come into play until after I die. So what happens is people have to go to court to get what's called a guardianship, and that gives some person that the court decides the authority to make decisions over your finances. But it takes several months to get this guardianship, and it costs several $1,000s. So now many of you are probably saying, okay, but that was the scenario if I'm a single woman. Let's say that I'm a married couple. And so my husband and I own our house together. We both have our names on the house. And we might even have it set up on the deed, if it's done properly, that if my husband dies, the house goes to me. But there isn't anything that happens if my husband gets sick. But if he can't sign to sell the house, I can't sell the house without him unless I have a financial power of attorney. So you can see, even a married couple, we can't do everything for ourselves. Have you ever tried to call Comcast and make a change when it's not in your name? If so, you have felt a little bit of the brunt of not having the legal authority to do things. The other part is, if you don't have an estate plan, then you don't get to choose who's going to make decisions for you. And I don't know about you, but there's some people in my life that I don't really want making decisions for me about medical or about finances. And so the court decides, and that could be based on a variety of different things, one being who has the most money to go to court and fight for it. So that's what happens if you don't have an estate plan. So what is a will, and how does a will fit into the estate plan? We talked about the powers of attorney that you need while you're still alive, but the will takes over as soon as you pass away. So the minute that I die, now my powers of attorney are not good anymore, and the will takes over. And it's just a tool that transfers assets from one person when they die to their beneficiaries. A common misconception is that if you have a will, that you won't have to go through probate court. And that is not true. So if you learn nothing else today, you need to understand that with a will, you usually have to go through probate court, depending on what assets you have. But most people with a will go through probate court. If you don't have a valid will, which I see a lot, and you might know, but over 60% of people 55 and over don't have a will. And so if you didn't have a valid will, what happens then? Well, the state has laws. Each state has laws about who's going to get your assets. And it might not be the people that you want to get your assets. So you'll still die if you don't have a will. Your assets will still be transferred, but it might take longer and might not go to the people you want it to go to. So let's talk about the secrets that a lot of people find as problems when they're going through their estate plan, because you make an estate plan and you really don't know for sure if it works until you need it. So maybe you have a financial power of attorney, but let me tell you, if it is not recent, like after 2017 in the last 3 years, most financial institutions will not accept it. So it has to be a recent power of attorney, and it also has to specify exactly the authority that you're giving someone. You have to sign it as the creator. You need 2 unrelated witnesses, so you can't have your relatives, your wife, your husband. It does need to be notarized. It has to have a date on it. It has to name who you want to make decisions on your behalf, which is called an agent. And it has to be in writing. I can't just say, well, Melissa, I want you to be my financial power of attorney, and that makes it happen. It does not. Although sometimes people think that if they just say things that works that way. And I think in times gone by, maybe it did, but now it does not. So you need it, needs to be in writing, and needs to be from 2017 or sooner if you want to use that. And I should specify that that doesn't mean that it isn't legal if it's before 2017, but financial institutions don't like to accept it after 2017. Dirty secret number 2. So your estate plan fails if it does not include a medical power of attorney. And this is where you give someone the authority to make medical decisions for you if you can't make your own decisions. So what do I need for that to work? Well, you have to name the person. I always like to have a primary person and then a successor, because I never know what's going to happen to people, to make decisions for me. So at least one primary, one backup. Somebody has to sign this. If you create this, you need to be the one that signs it. But you also have to have the 2 unrelated witnesses again. It needs to be in writing and it needs to be dated. However, with this one, it does not need to be notarized. So when would this come into play? Well, right now with COVID, a lot of people have been using their medical power of attorney more than ever, because if you have to go to the hospital and nobody can go in with you, you're taking your power of attorney so that you can give the medical staff the authority to talk to your agent, the person that you said could make medical decisions and get information from the doctors. That's how that communication is going on. A lot of times this is really critical when someone gets dementia, because they'll lose their ability to make decisions over a long period of time, and someone has to make decisions for them. Dirty secret number 3. So your estate plan is going to fail if it doesn't name a living executor. The executor is like the manager of your will. They're the person that says, okay, you got this will, you created it, you've got everything outlined there, and now you want it to go to certain people, you want it handled certain ways. The executor is the manager, the one that's supposed to make that happen. So you need to have somebody that is really trustworthy and responsible. And again, you want to have a successor. Now, this trustworthy and responsible, I should also add, not a procrastinator. I recently had a client come in, and mom and dad had passed away. The last one had went 10 years ago. Brother was the executor, but he isn't taking any action. He's never done anything. So their house is just sitting there empty for 10 years, probably, deteriorating in value. And the other siblings aren't able to get anything from the estate because the brother is not going through probate court and filing the appropriate paperwork. So don't pick a procrastinator for this. Dirty secret number 4, your estate plan is going to fail if you don't have successor beneficiaries. So sometimes people will put that this is what I want, and it's going to, when I die, it's going to go to these certain people or charities. But what if those people aren't there? Well, in that case, then we have to go back to, do you have a successor? If you don't, then we go to the laws of the state that says, how is it going to be distributed? So I gave you an example here that I have a will, and it's going to distribute 1/3 of all my assets to 3 children. Now, one of my children, unfortunately, has predeceased me. It doesn't say in this will how that's handled. And so what happens is now the court has to decide. Even though I'm an attorney, I think anytime you have to go to court and pay attorneys, that it's expensive and there are ways around it. So I want you to avoid having to go to court and pay attorneys. And so you can do that by having it very clear how you want your assets to be transitioned. And you can't leave any loopholes or your estate plan will fail and it won't work the way that you intended. So what are the options for this? Well, that one child, it could be that the assets that that third that child was going to get go back to the other 2 living children. It could be if that child had children of their own, it could have went to their children. Or it could be that if a child predeceased, then it went to a completely different person, or maybe it went to a charity. So you can see there's a lot of different dynamics that could happen. So you have to be sure to specify that. Dirty secret number 5. So your estate plan fails if it was signed under fraud or undue influence. So if someone took mom and dad, maybe you have a sibling or somebody else that took mom and dad to an attorney, and we're really putting a lot of pressure on mom and dad to leave everything to them. And so mom and dad weren't able to make their own decisions. And I see more often than not that this happens inadvertently. It's not intentional. But when mom and dad come in with one of their children, they have multiple siblings, but one brings them into the office. At that point, I always ask the child to leave the room so we can have the conversation. Because otherwise, mom or dad will say, well, to the child, what do you think? And this is not the child's decision. This is mom and dad's decision. In Georgia, the threshold is very low for making a will. You only have to be 14 years old. So you don't have a high bar or a high standard that's required to make a will in Georgia. You just have to be over 14. You have to know what assets you own. And then you have to be able to articulate who do you want them to go to. And it could be, again, as complex or as simple as possible. But if it hasn't been something that the creator wanted to do, if it's something they're pressured into, then that estate plan is probably going to fail. It's not going to work the way that they intended it to work whenever they set it up. Dirty secret number 6. If you try to disinherit your spouse and you live in Georgia, your estate plan is going to fail. In Georgia, a spouse is entitled to at least 1/3 of your estate plus a year of living expenses. So what does that mean? So in Georgia, let's say that you have a will and you have 3 children, and you say, I want all of my assets to go to my 3 children and none to my spouse. That is not going to hold up in court because the spouse has to get at least 1/3. And then how do we determine what the 1 year of living expenses is? And, it's something that's not really concrete and cut and dry, but the way that the court looks at it is, so what was spent on your living expenses in the last year before your spouse died? And that's the amount that should come off the top of the estate to pay for the spouse to live for the next year. So don't try to disinherit your spouse because you can't do that in Georgia. There's other ways to get around it, but you can't just do that in your will. Dirty secret number 7. If the executor doesn't have the original will, and this is the one that you signed, not a copy, then probate court won't take it. So if I have a copy of my dad's will and I need to go to probate court to get the assets to transition from my dad to whoever he wants them to go to, then I have to have the original will to present to the probate court. If I go in there and I don't have the original will, it's a copy, then it's just like my dad didn't have a will at all. And they'll look at the state laws to say how his estate is going to be distributed to our family. And in Georgia, if you don't have a will, what the state looks at is, 1, are you married? If you're married, then how many children do you have? So my dad is married and he has 3 children. In that case, if he didn't have a will, my mother would get 1/3 of his estate and us 3 kids would split the other 2/3 of the estate. Now, I don't know about you, but that isn't exactly what my dad wants, because him and my mom paid for the house and the things in their estate and accumulated the wealth. Us children, we more distracted from their wealth than contributed to it. And so he might not want everything to go to us as long as my mom is alive. What if there was only 1 child? Then the spouse and the child would split it 50-50. So you want to make sure that whoever is the executor has the original will. And don't write on your will. This is a legal document. I've seen so many people that will go and cross things out and do different things to the original will. You don't want to do that. It just makes it much more difficult down the road. Dirty secret number 8. So if you don't list all of your children in your estate plan, it's not going to work the way that you want. And you might think, well, who wouldn't list all of their children? I'm going to tell you, it's a lot of people. So what happens is that a lot of people will get a will whenever they're first married and have their first child. And so it says, mom, dad, first child, all listed in the will. And then all of a sudden, second child comes. Well, they got to remember to go back and update the will. And third child comes, and they got to go back and update the will, but they forget to do that. So many times, more than you would probably believe, children get disinherited because they're not named on the will. So if you haven't updated your will for many years, it's a good thing that you go and check that out, make sure all your children are on there. Another thing that would make your estate plan not work the way that you want is if you didn't name a guardian for underage children. So if you don't name a guardian, then the court has to decide who's going to be the guardian. And what does that mean? That means the court decides who the person is that is going to determine the religion, what school your children go to, what activities they're going to be involved in afterwards, really frame their life in all the ways that a parent does. So that's a really important decision. You'd want to make sure that you choose who that person is going to be and not leave it up to the courts. And it takes a while for them to make that decision. So then your family is in limbo. And that's really very stressful for everyone involved. So make sure you got all the kids' names on there. If you have underage kids, that you have named a guardian of the children. Dirty secret number 9. If you don't plan to pay taxes through your estate, then your estate plan is not going to work the way that you want. There's a lot of ways to minimize taxes if you plan in advance. Inheritance tax in Georgia, we don't have any, but there is a federal inheritance tax, but you have to have $11.6 million. I'm hoping many of you hit that threshold, but you don't pay federal inheritance tax unless you have over $11.6 million. But you do have capital gains taxes. You do have income taxes. And so what happens is the taxes come across and those are taken out before any of your beneficiaries are getting their inheritance. So let's say that you have, $100,000 that you're leaving to beneficiaries and you have a will. Well, your will is going to have to go through probate court. So that's going to cost you several $1,000s. You're going to have to pay taxes, which is going to be probably a CPA or someone. All of these things come off the top before the money goes to your beneficiaries. But there are ways, again, you have to plan in advance for you to minimize the amount that is taken out of your estate for other payments and goes more to the beneficiaries, because that's what you want anyway. So a friend of mine works for the IRS, and he says that, yes, you have to pay taxes, but you don't have to leave a tip. So if you don't plan in advance, you're going to be giving the IRS a tip. Dirty secret number 10. Your estate plan fails if you've not created one. So AARP says that more than 60% of adults do not have a will or an estate plan. And at the same time, people also say that it's a priority to not be a financial burden to their loved ones. So as you can see, those two don't go together. Without a plan, you are going to be a burden for your loved ones because they're going to have to figure it all out. So let me tell you a story. I'll tell you a couple different ones. One story is of a family that had a lot of assets, probably one of the higher net worth asset families that we've dealt with. And they came in and they had been to some prestigious law firms in Atlanta. They had worked with one for many years, but they kind of had a falling out. And they had wills and they even had a insurance trust and they had their powers of attorney and everything, but it was from 1999. And this was in 2020, so a little bit dated. But they came in because Dad has dementia, and actually he's at Solana, so one of the Arbor properties, and they're taking very good care of him. But they're worried because they don't know if everything's going to work the way that it's supposed to. Well, when they come in and I start looking at what they have, they kind of got a mess. They're definitely going to have to go through probate court. And because they have a lot of assets and they have a lot of real estate, and some of the real estate is in a corporation that's owned by Dad, and there isn't a plan for that, what's going to happen with that. Some of the other real estate is just in Dad's name, and the financial power of attorney is from 2019. And so we can't really transfer that at this point because Dad isn't, he doesn't have capacity to sign to transfer that so that we could avoid probate court. There are things that we can do to make this better. But if they go through probate court, first off, the prestigious law firm in Atlanta didn't tell them that there was any way to avoid going through probate court. And I'll tell you, a lot of attorneys say that or do that. They don't say that you have to go through probate court, but a lot of times it's built into your will that you need to use them to go through probate court, or they will be the executor when you go through probate court. So this family didn't know that you could avoid probate court, but there are ways to do it. And they happen to have one sister. There's 3 children, and the one sister is very antagonistic and not estranged from the family, but the family's kind of wishing they were. And so she keeps causing problems, and their concern is if they have to go through probate court, which requires a lot of decisions and signatures from family members, that it's just going to blow up. She's going to fight them for years, and they don't want their mom to be going, and mom doesn't want to be going through this through her last year. She's in her early 90s, and she doesn't want to spend her life fighting over, the wealth that they had built just because they have to go through probate court. So they could avoid going to probate court. They could avoid that whole family feud and all of the issues that are going to be involved with that. I had another client that recently came in. He had just turned 65. He was diagnosed with leukemia a year and a half ago. And he had an estate probably worth about $400,000, plus he had a house that was worth about $200,000. Well, with the leukemia, the treatment is very expensive, and he had maxed out his insurance. So he owed $400,000 to one local hospital and $600,000 to another one. So he had medical bills of $1,000. Now, if he has to go through probate court, or his family goes through probate court, they're going to take all of his assets because he has to pay off those debts. If he can avoid probate court, then he doesn't have to pay those, and his money can go to his family. And so that's what we were able to do. Unfortunately, he passed about 2 weeks after we got this straightened out for him, but his family was able to avoid probate court and use the money to support themselves now that he isn't there, and to compensate financially for his loss. So there are things you can do, but you have to have an estate plan, and the plan needs to be made in advance to avoid a lot of the different things that cause your loved ones a problem. So what happens when a will fails? And I touched on this a little bit ago for a minute, and it's just the same as not having a will. So if your will doesn't work, you might as well not have one. Each state has laws about who will inherit from you. So if you're not from Georgia, you'll need to talk with a local attorney to figure out what those laws are. And it may be that people will inherit from you different than who you want them to, or in different amounts. And again, if you're in Georgia, it doesn't all go to your spouse if you don't have a will. At this point, I'm going to caution you that not all of us attorneys are created equal. You're going to want to talk to an elder law attorney if you're thinking about developing a plan through the rest of your life. I look at people when they come in, and I just automatically start thinking about what I call the curveballs of life. They come and they get each one of us. We're all old enough to have gotten a few of them by now. And I want to make sure that whichever curveballs you get in the future, that you are protected from those. And that's something that not every attorney can do, but a lot, probably most attorneys think that they can create a will because they think it's just a one-page kind of form, where it's really not. Somebody needs to get to know you. They have to have the expertise in this type of law to make sure that your estate matches your situation and what you have going on in the future. But if you do have a valid will, then you get to decide who's going to be that manager or executor of the will. You get to decide who's going to inherit from you. you can also eliminate a lot of legal costs. So we want the money to go to your beneficiaries, not to the court systems, not to lawyers. But it also reduces family feuds. How many of you, if you could just say something in the chat, yes or no, know of a family that has never talked again after somebody has passed away? I think that many of us have. Just again, put yes or no in the chat where the Q&A are so that we can see, have you ever seen that? But if you have a plan, then the inheritance is received faster, which reduces the number of feuds that go on, and hopefully your family will continue to have a good relationship afterwards. Some of the things that we've built into some of the estate plans that we've done is maybe the kids are not that close, but the parents want them to be close, and they're always concerned that the kids won't ever talk again. So sometimes we've talked with the parents and decided that the kids should just go on a trip, either with their family or by themselves, to give them a really good bonding experience and to make some new memories after mom and dad have left, so that they have their own traditions that they can start that will keep the family foundation stronger. So doing an estate plan, you have many options. It's not a DIY project. Many people will ask me, well, what do you think of LegalZoom? And actually, LegalZoom isn't bad if you know what you need, but you probably don't know what you need. So a lot of times we get the results of LegalZoom where someone has used it, they haven't completed it correctly, and it ends up that it's the same as not having any will at all. And there's many attorneys with a lot of skills. Just make sure that the attorney that you work with has the skills that you need for what you're trying to achieve. And this is not a good time to look for the cheapest price. If you want the cheapest price would probably be that you just write it out yourself. But you're not going to know if that works or not until it's really too late. So you really want to make sure that you do this right. And this isn't for us as individuals. This is for the people that love us. So I like to say, without a will, there is a way. It's just not the way you wanted it. So I'm in the business of helping people protect their life savings and the people that they love. So I'm going to open it up now to Melissa for questions.
Fantastic information. First of all, thank you for the awesome advice, Cindy. I know we have quite a few people on right now who are watching and taking everything you have said into account. We do have some questions here, so if you want to grab some water for a second, we've got quite a few to get going. So let's just hit the Q&A, and let's start at the top with a question from Roger. Roger wants to know, what is petition for years support in Georgia? What does it include, and is it in place of processing a will or in addition to it?
Oh, that's a great question, Roger. So it is not a replacement for processing a will. It's another step above and beyond. And what's included really depends on what your life was before your spouse passed away. And so the idea is to give you the same lifestyle after losing your spouse as you had before losing your spouse. So you get 1 year to kind of make this adjustment. You can get the 1 year of support so that you don't have to worry about how you're going to pay the bills and that type of thing right away. The court recognizes that that's a huge impact on us when we lose someone we love, and especially a spouse. And so they give you some leeway. But there isn't one answer, and you find that a lot with law. There isn't one answer that's black and white. It all is dependent upon the specific situation.
And let's follow up on that part of it, because I think that is very key. So if you're tuning in and watching now and you are not in Georgia, we have been talking really about specific law, elder law in the state of Georgia, correct?
Yes.
Yes. So, and these laws will be different from state to state to state. And that is why, as you said, it is important to seek somebody out who does this for a living. And if you want to do it yourself, as you said, you can go that route, but you're going to miss out on a lot of the perks and a lot of the things that are necessary to make this an easy, smooth transition for your family by not seeking out a qualified attorney. So great stuff. All right, so let's move on to Rochelle. She has a question. Do you have to name grandchildren if you are not leaving them anything in the will?
No, you don't have to name anybody in the will. If you're not leaving somebody as a beneficiary, then they don't need to be named. But even you don't even have to name your children. You could say that I just want my entire estate to be split. 50% goes to my children and 50% goes to this charity. And this is where we've seen, like Prince and some other people, though, that have gotten into a mess because they didn't have an estate plan and it's not really clear who their children are. So if there's a doubt about your children, you might want to name them, but you don't have to. And if you're not leaving anything to your children, you don't have to name them at all. But you can use specific names. You can use categories. So when people do want to leave something to their grandchildren, if their kids are young enough that they might already be having or already have some grandchildren, but young enough to continue to have more, I just wanted to say to all my grandchildren, because that way the future ones are already included and we don't even know that they're going to be future ones for sure yet today.
Yeah, great answer. Great question. Patty has the question, can you differentiate between what you mean by estate plan and trust?
Yes, Patty, thank you for asking that question. So a trust is a tool that's used in an estate plan or can be used. It's not always a requirement, but a trust is a way that you can do things above and beyond what you are able to do with a will. So for example, first let me tell you that a trust is a legal entity. It's not a physical entity, it's just a legal entity. And by that, if you think about a corporation is a legal entity. The business itself is the physical entity, but it's just got this legal wrapper around it. And it has provisions in that wrapper about how that business is going to be run. So a trust is a legal wrapper around your estate. And it has provisions in there about how your estate is going to be run. With a will, when someone passes, that day, you can't carry things on after that. So whatever is in the will that day, that's it. But a trust can carry on further than what the will. So let's say, for example, let's say that I have a child that has special needs. And so in my estate, I'm going to leave things through a trust to a trust for this child. And maybe one of my other children is going to manage the money for the special needs child. That can go on for decades, and as long as the other child with special needs is still alive. So there's so many more things that you can do with a trust that can't be done with a will.
Follow up from Patty. When you identify beneficiaries, do you need to provide their social security numbers?
Not for me. Of course, other lawyers might want it differently, but I don't want the social security numbers because I don't want that kind of information in any kind of document that's floating around.
So then my follow-up to that is it necessary? So if they're talking to an attorney, is this information necessary or not?
The children's social security number is not necessary.
Excellent. Great. Steve's question, why do you not mention living revocable trust?
trusts are like a whole nother webinar that we could go into the different types of trusts and all the things that you could do with trusts, and there's a lot of them. But revocable living trusts are a way that you can avoid probate court if it's set up correctly. So great question.
All right. So for those of you who may have joined us a little late, we are talking to Cindy Nelson. She has 2 law offices in the Atlanta metro area dealing with elder care. She has been gracious enough to give us her time today and is answering some of your questions. So you can type in your questions at the bottom of the screen there in Q&A. And we're going to go to the top of the hour. So we have about 15 more minutes remaining here with Cindy. So get your questions in if you have anything you would like answered today. Jan is next. Her question, what does per sterpie mean?
Oh, again, so in the law, I think maybe every profession does it, but within the law, we use different phrases that have very broad meanings, but most people have never heard of it before. So thank you for asking the question. Per sterpie means that if I'm going to leave my estate to my children per sterpie. So that means I have 4 children, that my estate gets evenly divided amongst the 4 children. But if one of my children predeceases me, then that child's share goes to their children, not their stepchildren, just their blood children. Now, if they've adopted a child, then that child's included as a beneficiary. And it can keep going down the line, but it goes down the line of the blood. That's what per sterpie means.
Even I'm learning something new here today. I had no idea what that meant, but now I do. And you gave us that definition so well and so clearly in layman's terms. And I know all of us can certainly appreciate that. So thank you for that, Cindy. We have another question. This one's from Anonymous. How often should you update a trust if no changes have occurred?
Well, if there's no changes, then you don't have to update the trust. And just so you know, trusts are at the national level. Those are not different by state. So there's national laws that are for trust rather than state laws that are for powers of attorney and wills. But when you say that there's no changes, I would want to think about that a little bit because everything in life changes. And so let me tell you some of the things that I want to know. I want to hear from my clients if they're going to sell a piece of property or buy a piece of property. And the reason I want to know is because they probably don't know how to make that transition with the trust on their own. I don't have to really do anything, but I'm going to tell them in 5 minutes how they need to make that happen so that the trust still works. I also want to know if one of their children gets a significant illness, or if one of them, the spouses, get a significant illness. The reason being is that if it's one of the spouses, we might need to go more in an asset protection mode. Again, nothing legal needs to change, but we might want to change how we're utilizing assets from the time when they were younger and healthier to a time when maybe they're not as healthy, and looking at the cost of care in the future. So things like that, you know, I want to make sure that their grandchildren are in there, that they didn't just want to name it. I don't like to do that, but a lot of people want the specific names of their grandchildren. And so then you have the risk of losing out on somebody not getting named as future grandchildren. So those kinds of things, I just like to be kept in the loop on, because when we do a plan, I want to make sure that plan works for you for the rest of your life. So if really nothing has changed, then you really don't need to talk to anybody about it, as long as you're sure the plan works the way that you want it to now. If you have any doubt, you need to talk to somebody.
Absolutely. And we've got a couple more questions in. We're going to try to get these all in the next 10 minutes or so.
Okay.
So Jan, she says, what happens if you have one child that is estranged? Will he, she be able to know what was left to the other children or grandchildren?
It depends. If it is a will, then yes, even though the child is estranged, it will have to go through probate court. That child will need to be found, and on several occasions throughout the probate process, will be required to sign documents before the other children will get their inheritance.
Okay, great answer. Robin, her question, or his question, by law, what is the executor of the will required to show beneficiaries on the distribution of assets? For example, the value of an art piece that will affect the financial amount to be distributed.
Yes, for a will, the beneficiaries are entitled to see the entire inventory of the estate and how much each asset is worth, how it was distributed, every detail of the estate they are entitled to know.
Patty is looking for some clarification here. She says, my current estate lawyer is recommending I update my documents so that I have a living revocable trust with a pour over will. Can you please clarify what this means?
Yes, I can. So let me start with the pour over will, in that a pour over will says that everything I own, whatever I pass away, is going to go from the will to the trust, so that I don't have to go to probate court. And then the revocable living trust is going to be the way that my assets are distributed. And so your current attorney is probably trying to help you to avoid going through probate court, which I think is a wise decision. You have to make sure that everything is set up correctly so that it works that way. A lot of times attorneys don't do the follow through. They create the legal documents, they give them to you, and then you're supposed to go do homework, and if you don't do it, it doesn't work. So most people don't go and do that. We actually have someone in our office that is a funding manager. Her whole job is making sure that the trusts are funded correctly so that they will work the way that they're supposed to.
Excellent answer. This is from Lucy. Can a CCRC facility, and I'm assuming this means continuing care retirement community, garnish the assets within a trust for expense?
It's going to depend on the contract that you sign whenever you entered the CCRC. And each of them have a little bit different contract. And so I can't answer that without knowing what that contract was that you agreed to. But you probably want to get a lawyer to look at that if that's something you're concerned about.
This is from Catherine. If a financial POA is signed, but the person gets dementia, is the POA still valid until the person dies?
And so I think that what you're saying is the creator of the POA gets dementia. Is the financial POA still valid? And most of them are. It needs to be written correctly, but most of them are. That's the idea of the power of attorney, is for when we become incapacitated.
Okay. And our last question comes from Tricia. How does it work if I live in one state, but my executor, beneficiaries, etc., all of her relatives live in another state? She asked, should I have my will written by an attorney under their state or where I currently reside, if there are different laws depending on different states as to how the will be executed? And she wants to say thank you for your excellent insight today.
Oh, well, that's sweet. Thank you. So you have to do it where you live. Even if your beneficiaries, executor, everything are in another state, the laws of that state don't rule for you. The laws of the state where you live rule. But let me take it one little step further, and that is if you owned property, let's say you lived in Georgia and you had property in Georgia, and that's where you had your residency was Georgia, but you also had a place, let's dream big, on the beach down in Florida, right? And so you had two places. you actually have to go through probate twice. Once in Georgia, which will take care of the Georgia property, and then once in Florida for the Florida property. Yeah, so you definitely want to trust if you own more than one piece of property or in different states.
And we do have a couple more minutes here, and I actually have a question that sort of follows up Trisha's question. My husband's parents are older. They have a will. They have everything together, and they have given it to their son, my husband, who also has a JD like yourself. They live in a different state. He has not looked at the documents. It feels a little uncomfortable, according to him, to want to look at those documents. I assume that is probably a common issue, that you don't want to have to face your parents' mortality. And for him, it's very difficult to even want to open up the documents to look at it. I have been encouraging him to do so because there could be questions, and it's better to ask the questions while they're still here than to maybe guess what it is that they wanted. How do you, or what advice would you give somebody in that situation?
Yeah, I would actually recommend that your husband in this situation have an elder law attorney look at those documents from the state where his parents live.
Okay.
And have them go through and make sure that it's all set up to work the way that it's supposed to. Mm-hmm. Because one of the things that motivated this presentation is that a lot of times we think that everything's set up and we got a nice bow on it and it's perfect. Yeah. And it might have even been at the time we did it, but things might have changed with the law or whatever that you don't know about. That's why I was so worried about no changes. You know, do I need to have someone look at it? Well, how do you really know there's no changes? But so I would have someone from another state look at that, understand what assets they own, how those assets are titled, whether they have beneficiaries on them, and go through it end to end.
Great. And we do have maybe 2 more minutes here. Yep. Susie is coming in at the last minute here. She's flying into home base and has the final question for us. My documents were drawn in one state and I moved to another state. Do I need to update my documents?
Yes, you do.
Simple answer.
Simple answer.
You do, Susie. You have been a wealth of knowledge. Here's Cindy Nelson, everyone, the founder of Nelson Elder Care Law. We appreciate your time today and, of course, all of your valuable advice. For those of you watching, in case you missed the last slide for Cindy, that had her information on it, and you have a pen and paper ready, jot this down. If you have any more questions for her or would like to utilize her services, you can contact her at www.nelsoneldercarelaw.com or 678-250-9355. Cindy, thank you so much for your time today.
Thank you, and Arbor, Melissa. Thank you very much. And thanks for everybody for attending. It's been a pleasure.
Now, those of you watching, you can catch this entire webinar tomorrow at www.seniorlivinglive.com. There you can also find many other videos and content all related to senior living. Thank you all for joining us today. And as always, have a great day, everybody.